In this video, we're going to begin talking about breach of trust, and this will form two separate videos before we move on to talk about remedies and defences with regards to trusts. So let's get started. Now, where a trustee fails in his duties, the beneficiary may have a claim in breach of trust. However, the beneficiary must show not only that the trustee failed in his or her duties, but that the breach caused a loss. So the beneficiary must show if a trustee breached the trust, the breach caused a loss. If the breach didn't cause a loss, then that doesn't matter. So a breach of trust isn't actionable per se. You're not entitled to any damages purely by virtue of the fact that the trust has been breached. Investing in an unauthorized investment, for example, would not by itself give rise to a claim. The beneficiary would have to show that the unauthorized investment was less profitable than the investment that should have been made. For example, if a trustee invests in an authorized investment that would not in itself give rise to a claim, despite being a breach, the beneficiary would have to show that the breach caused a loss before any action can be taken. The beneficiary might insist that the money was reinvested in an authorized manner, but would have no other remedy. So this is really the only remedy that would exist in this particular scenario. It would require the trustees to take remedial action by reinvesting the trust money. And we've got a case here of Armitage and Nurse. And in this case, Millet said that breaches of trust are of many different kinds. A breach of trust may be deliberate or inadvertent. It may consist of an actual misappropriation or misapplication of the trust property, or merely of an investment or other dealing which is outside the trustee's powers. It may consist of a failure to carry out a positive obligation of the trustees, or merely of a want of skill and care on their part in the management of the trust property. It may be injurious to the interests of the beneficiaries, or be actually to their benefit. So breach of trust can happen in a lot of different ways. It could be, casual carelessness or actual fraud. So a breach of trust may actually be beneficial to the beneficiaries too. For example, if a trustee invests in something he shouldn't have invested in and that investment makes a greater profit, technically that is a breach of trust, but a court wouldn't actually give a remedy for that. And we've also got this quote from Lord Brown Wilkinson in Target Holdings and Redferns, which is a key case, which we'll look at in just a second. And it says, the basic right of a beneficiary is to have the trust duly administered in accordance with the provisions of the trust instrument, if any, and the general law. So the beneficiaries can insist the trustees stick to the trust instrument, but no more than that. So although the court will enforce the above, in other words, ensure trusts are duly administered, it doesn't mean they will always give a remedy where there has been a breach. And so this leading case that we're going to look at now is Target Holdings, which is a House of Lords case from 1996. And this case arose from a complicated land deal in which Mirage, the owner of a commercial property, agreed to sell it to a company called Crowngate, and Target Holdings agreed to provide a loan secured against the property for £1.7 million, believing that was the sale price of the property. So this was a seemingly straightforward sale from Mirage to Crowngate, with Target Holding acting as the mortgagee. In fact, the property had been sold for £775,000 to a company called Panther, which sold it on to a company called Coley before selling it to Crowngate for £2 million. Panther, Coley and Crowngate were all controlled by the same group of people. So Target Holdings provided a loan of £1.7 million, believing that to be the price of the property, when in fact it had been originally sold for £775,000 to Panther. Then it went to Coley, then finally on to Crowngate for £2 million. These three companies, so Panther, Coley and Crowngate, were all owned by the same people. So what was happening was that the company bought the building for its actual value of £775,000 and then sold it to themselves through various different guises, and therefore artificially increasing the value of the building. Having given the impression that the building was a lot more valuable than it actually was, they were able to secure a mortgage for £1.7 million on the property. Okay. Transfer then targeted the loan monies to Redferns, who were the solicitors acting for all the companies which were involved as buyers. The following day, and before the first sale was completed, Redferns then transferred most of the money to the account of Panther, one of the buying companies, and the remainder to Coley a few days later. The purchase price was then transferred to Mirage, the original seller, and the rest of the money was transferred to other parties. In other words, the solicitors. Okay, so what happened then was Target Holdings agreed to lend £1.7 million for what they believed was a safe loan, as that is what they think the building is worth. So, as normally happens in these transactions, the mortgagee gives the money to the solicitors handling the deal, subject to an undertaking by the solicitor that they will not hand the money over to the seller until they have received good title to the property. In other words, until the sale is complete and the property belongs to the buyer. Redferns represented all the intermediary companies, that is Panther, Coley and Crowngate, and one solicitor had followed the transaction from start to finish and acted for all the individual sales. So a fair-minded observer would probably have noted something dodgy was going on. But this case is not about dishonesty, it's about breach of trust. And for the purposes of this case, the House of Lords seemed to be presuming that the solicitors were acting properly and in good faith, although they do note that the transaction was redolent with fraud. This case is not about fraud, as I just mentioned, it is about breach of trust. Now, the company itself had disappeared, so the only person left to sue was the solicitors, Redferns. So this case, where they were trying to hold this was a case where they were trying to hold the solicitors liable for the breach of trust, because the money transferred to the solicitors was given on an express trust of the beneficiaries of Target Holdings. So Target Holdings give the money on an express trust to Redferns for Redferns to hold that money on trust for Target Holdings, with the power to pass it on to the seller when they received good marketable title to the building, which is a standard condition of property sales. And the following day, £1.7 million was handed over to two of the fraudulent companies, Panther and Coley. Then £775,000 was handed over to Mirage, the original owner. So Mirage got their money. The company had managed to raise a loan on the property at £1.7 million on a sale worth £775,000. So they made about a £1 million profit. So Panther and Coley were fraudulent companies set up solely to channel this money to the people behind the fraud. Now, by transferring the money to Panther and Coley before the property had been transferred and the charge on the property completed, Redferns committed a breach of trust. So, in other words, the money was transferred to Panther and Coley. They paid Mirage the £775,000 purchase price, then kept the £1 million extra money and vanished. So the money was untraceable. It had been transferred offshore and they could not trace anyone involved in the company. The only person left to sue was the solicitor who acted in all of these transactions of the property. By transferring the money to Panther and Coley before the property had been transferred and the charge on the property completed, Redferns had done something they were not allowed to do under the terms of the trust. So there had been a breach of trust. And just to put this another way, money was transferred to the fraudsters as soon as they had received it, and therefore before title had in the property had been properly transferred. So they had acted outside their powers to give money to the seller once title had been registered in the name of the buyer. So they jumped the gun and didn't wait for the title to be transferred. Target Holdings found out what was going on and demanded their money back. And the House of Lords held that the principle of causation, in that the breach must have caused the loss, applied to breach of trust. In this case, the loss was not caused by the breach, as the money would still have been paid over, albeit about a month later, before the fraud was discovered. Accordingly, the defendants were not liable for the loss suffered by the plaintiffs. So Redferns had received the money and transferred the money to the fraudsters. Then they registered title in the building in the name of the buyer. So those two acts had been done in the wrong order. In other words, title should have been registered before the transfer of property. Now, these two events happened fairly quickly after each other. And so what the House of Lords held is that to recover compensation for breach of trust, you must show that the breach caused a loss, and in the case, it did not. The loss was not caused by the breach because nobody discovered the fraud until some time later. So although Redferns breached the trust by handing the money over too early, even if they had waited to transfer the money once title had been registered, this would not have prevented the fraud from going ahead. So because the breach of trust, that is the handling of the money, handing the money over before the title and the property had been registered, did not cause the loss, Redferns were not liable. Target Holdings were unable to show that this breach caused a loss. But note that this was just one element of the legal action that was taken in this particular case. So although Redferns were not liable for this, it does not mean that they got away with it. Okay? So I hope that makes sense. I try to explain this case as clearly as possible. I know it's quite a difficult case to understand because there's lots of moving parts, but if you just listen to this, listen to what I said a couple of times slowly, then hopefully you grasp it and understand it. So what did they say? In the House of Lords, they said there can be cases where, although there is an undoubted breach of trust, the trustee is under no liability at all to a beneficiary. For example, if a trustee commits a breach of trust with the acquiescence of one beneficiary, that beneficiary has no right to complain, and an action for breach of trust brought by him would fail completely. Again, there may be cases where the breach gives rise to no right to compensation. So in other words, even if there is a breach by a trustee, the trustee will not always be liable to the beneficiary. Emphasis needs to be on the need for causation if the beneficiary is to get compensation for a breach. Say, as often occurs, a trustee commits a judicious breach of trust by investing in an unauthorised investment which proves to be very profitable to the trust. A carping beneficiary could insist that the unauthorised investment be sold and the proceeds invest in authorised investments, but the trustee would be under no liability to pay compensation either to the trust fund or to the beneficiary because the breach had caused no loss to the trust fund. So as we said before, if there is no loss caused by the breach, then there is no liability. This is what the House of Lords is saying in this case. But the use of language here is pretty interesting. He seems to almost be endorsing trustees to behave in this way. And, he says the words like judicious breach of trust, as if to say it's a well-judged breach of trust. And he also talks about carping beneficiaries, meaning they're not only complaining, but they're complaining in a slightly unjustified way. So it's very interesting language used by the court in this case, and specifically Lord Brown Wilkinson. And it continues, therefore, in each case, the first question is to ask, what are the rights of the beneficiary? Only if some relevant right has been infringed so as to give rise to a loss is it necessary to consider the extent of the trustee's liability to compensate for such loss. So compensation is only available if it causes a loss. And that's about it, really. So, this is a very long-winded way of saying exactly that, and this is really what I wanted to get across in this particular video. So finally, reaching his conclusion, Lord Brown Wilkinson, giving the only judgment, was influenced by the possibility that breaches of trust might impose liability on a trustee, even when there was no bad faith and there was no loss to the trust property. And so his view here was endorsed by the other four members of the House of Lords in this case. So that's why Lord Brown Wilkinson gave the only judgment. And he was particularly concerned that trustees were acting in good faith. who did have the best interest of the beneficiaries at heart should be liable even if there had been no loss. Okay, so yeah, that about sums up this case, and I think that should explain it pretty well. I've tried to cover it in as much detail as possible without getting it too confused and too messy. And I think the short conclusion that you should take from this case is really that, yeah, if there's a breach of trust, there needs to be some loss caused, and that is the general summary of what we've talked about today. In the next video, I'm going to continue talking a little bit more about a couple more cases with regards to breach of trust, including AIB Group and Mark Redler, which is a big case as well. And that's before we start talking about liability and the specific ways they can get some form of redress for breach of trust. But if you have any questions about this particular video, then please do leave any questions below. Make sure you properly understand the target holdings in Redferns case, and if you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.